Appeal for the 5th District of the State of Florida is now in session. The Honorable Richard D. Workmayor, Judge, presiding. All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated. Good morning and welcome to the 5th District Court of Appeal. As the Marshal indicated, I'm Judge Orfinger, and we're joined on the panel today by Judge Sawaya to my right and Judge Lambert to my left. We have two civil cases today, so the parties will have 20 minutes per side. The clock is set at 5 minutes for rebuttal for the appellant. If you want something other than that, let me know, and I'll be happy to set the clock. When it flashes orange, you're into your rebuttal time. The third case on the docket, Chapman versus Deutsche Bank, oral argument was dispensed with, so hopefully no one's here for that. We'll take the cases in the order that they're set, with Hitchcock being first and Ferris being second. If you have a cell phone, please silence it so that we don't interrupt the parties. And with that, we'll go ahead and get started with Hitchcock versus Mahaffey. Good morning, sir.
Good morning, Your Honors. May it please the Court, my name is Michael Clark, and I'm here today on behalf of the appellant defendant below, Penny Hitchcock. I'm requesting the relief on behalf of Ms. Hitchcock that this Court reverse and remand and instruct the trial court to enter judgment for Ms. Hitchcock based upon a pre-suit settlement agreement. Alternatively, there is a request for a new trial on all damages due to the errors that are outlined in the briefing. And finally, failing that, we ask that there be a remand and direct for further remitter proceedings on calculations of damages that are not supported by the evidence or otherwise excessive. As Your Honors know, this is a motor vehicle negligence case. Its origin is one of admitted negligence. There is no comparative negligence defense below at all, and there was an amendment to include punitive damages because of the fact that Ms. Hitchcock was under the influence of alcohol at the time that this accident had occurred. The trial court, in conformance with the grace procedure, bifurcated the trial, but there was a single voir dire proceeding in which the jury heard
What do you believe is your strongest issue or argument for reversal in this?
Well, the issue that I want to talk about first, Your Honor, is the voir dire issue. And
That's your strongest issue for reversal?
no, I think the strongest issue is the settlement issue, the enforcement of the settlement agreement.
Okay. Oh, okay.
Okay, and I'll turn to that issue first.
All right.
Based upon the facts that are before the court, Ms. Hitchcock was represented by an attorney. I'm sorry, Ms. Mahaffey was represented by an attorney named Bonnie Shaw, who was her niece in the state of Georgia. And in the
I think we understand what happened. I mean, the bottom line is they offered to settle for $50 if you got the checks to them in about a 30-day period at a specified address. It got FedEx to a different address, but in the interim, your client sent an email that said, "We accept, and here's a photocopy of the check." The question is, how do you distinguish our cases of Trout versus Apicella and the Noling versus somebody?
I would like to talk about a Trout first. And I know Your Honor was on that panel. And the argument that we present is one of unconditional acceptance and mutuality of assent. So we know when we're talking about settlement contracts, we're treating them as contracts, and there has to be an unequivocal acceptance of all of the terms of the offer.
And I think one of the terms, and I think Judge Orfinger's question is a good one, so you can continue, but I just want to make sure, one of the terms was that the checks would be in the office at a certain location by a certain time, right?
The term as stated in the demand letter was delivery Delivering.
Delivered to this office by a certain date, by a certain time, and then at the address. I just want to clear, I mean, you concede that.
I do, Your Honor. That is the plain language of the offer states delivery to a location by a time and date certain.
Okay, now you can go back to Judge Orfinger's question.
And this court's analysis in Trout talks about the mirror image rule. And before we get to performance, what I've asked and what I've briefed is for the court to look at the idea of the mutuality of assent and the act of accepting an offer. And in the Trout case, it talks about the mirror image rule. And the reason that the court reversed in that instance was the attempt to accept failed because it didn't meet the terms in providing a release that was broader than the one that was permitted by the terms of the offer, and also because it failed to contain some statutory disclosures of insurance. And in the language that the court used in that case was that this was just in the nature of a counteroffer. When you sent these documents in response to the offer, you didn't meet the terms of in the mirror image of the offer, and therefore it's a counteroffer. And we're going to reverse, and we're not going to enforce the settlement agreement.
Wasn't the real holding of that case that Trout's offer to settle was an offer of a unilateral contract that required performance as an essential element?
I think,
to me, is the holding of the case that, now, you know, maybe they would have a material, there might be a materiality. If they had sent a condition that says it's got to be delivered at 5 o'clock at this address by a guy wearing a green suit, and he shows up in a blue suit and everything else, I wouldn't consider that material. But getting the dough to the right place at the right time seems to be more material. So why doesn't that holding of the case that it says performance was an essential element, why isn't that determinative here?
well, you've moved on from my first argument, which is the acceptance by mutuality of assent, which I'm sure the court will consider. But when we talk about performance, I think in this instance that the facts are particularly telling in terms of evaluating whether the performance occurred within the common sense reading of the offer itself. Now, you know, my argument was presented as, and the facts show, as the court already knows, it was addressed to the prior attorney's, the attorney's prior address. It was delivered by FedEx on time, so to speak. It was sent contemporaneously with an email that was acknowledged to be received by the attorney. And it was also acknowledged to have been received. The email was acknowledged to have been received by the attorney who put forth the offer. And what I've argued, as the attorney sat silent for those 3 days between the date that it was delivered to her former office, had been delivered by email, and was actually, copies of the checks were actually in her possession. What I've argued is that the common sense reading under this court's de novo standard of review of the term deliver, where that had been left undefined, could include that delivery within that. And part of that argument is
You
based...
didn't deliver the checks for a year later, then? The real checks, not the pictures of the checks.
I'm sorry, Your Honor.
You seem to say, well, we had a deal because I showed you the copies of the checks. Would it, you know, instead of the checks being sent 5 days late, they were sent 5 months late. They just didn't get around to doing it for whatever reason. You still say, well, we had a deal because you got we answered on time, we showed you the pictures that we were going to send you, and we just didn't send it to you?
Well, I think that the further out you draw the line, that the more difficult it becomes to support the argument of what a timely delivery would be. And of course, I have to concede those points. And I do that with the idea that there's no question that the checks were sent, received, and followed up by emails and phone calls and acknowledged that they were received. So the timeliness aspect that the court is indicating has to be part of the evaluation is one where they were in the possession, and you know, the appellee makes a big deal out of the fact that there was no authority given for her former, the suite mate attorney to accept it, but they did accept it and sign for the package.
They got a package there, and I mean, so what? FedEx shows up, and they see there's a package, and say, well, we'll let her know, and what is the significance of that?
The significance of that is that they didn't refuse it, because they accepted delivery of the actual physical checks.
If an unauthorized person accepts delivery, if you had sent the checks here, I mean, we get FedEx stuff all the time, and they just drop it off in the clerk's office, and, you know, somebody gets around to opening it, and they say, well, this should have gone to Mr. Shanin's office. You know, is that delivery? If it's an unauthorized, why was that person any more authorized than I would be to accept those checks?
Because of the circumstances of the address being the attorney's prior address, and when we say accept, and Judge, I am not an expert on Federal Express. I looked in the record to see if there was someone where it indicates that someone had signed for it, as opposed to it being a drop-off, as you've indicated. I couldn't find any evidence of that in the record, so I don't want to make a misrepresentation. But generally, packages are delivered and they are accepted for delivery. So that has been our argument since the very beginning in the case. Because we have to deal with the fact that the court has seized upon, which is that it did not go to the correct address.
Why don't you, in your remaining time, why don't you move on to your other issues in case that one doesn't carry the day?
All right, Judge, the one that I would particularly like to talk about is the voir dire issue. And I understand it's not a perfect system. We have a bifurcation system in place that is designed to alleviate the prejudice that is inherent in the evidence in the compensatory phase of a civil trial of alcohol use coming in. And there has to be some sort of control on that jury that's going to hear the first part of the trial, because as we saw in this case, the second part, the punitive damage part, resolved. And
Nobody knew that at the time of the voir dire. Would it be relevant, for example, in a case that involves alcohol and the potential for punitives? For example, if a potential juror was a member of Mothers Against Drunk Driving or Mothers for Drunk Driving, I mean, do you think either side would find that sort of an inquiry relevant?
I think that is a relevant inquiry, Your Honor.
Or, you know, are you an active member of AA, for example? And those are relevant. So if they're relevant, how does a plaintiff who is in this position get to make those inquiries if you're going to have the same jury decide both parts?
They make the inquiries the way that this trial judge suggested the first day, which was not to use language that links the causal connection of this accident and these damages to the use of alcohol.
Well, if they started talking about alcohol, wouldn't that kind of raise the red flag to the prospective jurors that, okay, they're asking me about alcohol, whether I'm a member of MAD, whether I'm in AA, whether I've ever had a family member hit by a drunk, you know, affected by a drunk driver? I mean,
yeah, and what I attempted to say was, what you don't say is in this case there's going to be evidence that alcohol was involved in this accident. I mean, the alcoholism could have impacted Miss Mahaffey's healing process because she was an alcoholic. She didn't heal as well.
but in the punitive damage stage, they would hear stuff about alcohol, wouldn't they?
Well, they would.
So they'd have to know about, you know, do I want to have this prospective juror sit in a punitive damage claim case if, you know, they're on a Mothers Against Drunk Driver. I would think if I were your son, I'd want to know if there were Mothers Against Drunk Driver, you know, members on the panel.
And as the court knows, that was a question that was asked in follow-up by Ms. Hitchcock's counsel. But what I've tried to say is, and if I haven't made the point artfully enough, is that the questions about alcohol and involvement with community services or relations like Mothers Against Drunk Driving or for the personal well-being and AA, you don't have to say, in this case, there's going to be evidence that alcohol was involved in the accident. And that's the key, because under the facts of this case, and the court is aware of the facts, this was a midday pre-bride or pre-baby shower accident that is inexplicable, but for the fact that Miss Hitchcock was impaired at the time that it occurred.
How do you respond to your opponent's argument that this issue's been waived on appeal?
Judge, I looked at the cases that were cited in response to that, and they dealt with the issues of peremptory challenges and failing to renew the objections because of the use of the challenges. And I think this issue's different. I think that it's a motion to strike the...
If I'm sitting as a trial judge and on day one, these issues of alcohol, in your view, become improperly brought in and I overrule the objection, and then 36 hours later, when we're finally to get to the panel on day two, you don't raise any issue with me, you preserved it?
I've attempted to distinguish the cases based upon the facts, but I would think that it's sufficient to raise it at the time.
Why shouldn't I, as a trial judge, think that you're really happy with this jury? You all found that they're people who drink a lot and they're okay with drinking and they don't hold that against anybody, and you think, yeah, it's probably the best panel I'm going to get.
It's a fair question, Your Honor, and I think that under the
Answer.
I'm sorry, what's
my fair answer?
Sometimes it's difficult to hear when...
Go ahead.
My fair answer is that for the purposes of this appeal, that the objection was made contemporaneously, the motion for mistrial was made and it was denied, and there was a period of time. I can't speak for the trial tactics, and I know that that's what the court is getting at. Was it a strategic decision? I see that I'm in my rebuttal time. I do want to address one other argument that I want to make sure that the appellate has an opportunity to respond to if he chooses. And that has to deal with the closing argument. And I know that we're under the Murphy standard here, and I know that it is a very stringent standard. But when you look at this argument, you will see, and it is plain as the nose on my face, that there is a clear point of demarcation where the argument changes from the economic damages to the non-economic damages. And it's at that point where, I did not see any argument in the answer brief that said that this argument was not an improper golden rule argument. It strikes me as probably the most plain example of one that you could find when you're asking jurors to whether or not they would volunteer to suffer the same damages that Ms. Mahaffey suffered. So in looking at the application of the test, improper golden rule arguments are improper and they are harmful. We know that. Whether or not it's incurable, and I looked at this court's case.
Did they actually ask how much would you take to go through this suffering, or did they talk about a generic, who would volunteer to do this, to go through this pain and suffering from this accident?
They asked, would you volunteer? Yeah, that's my objective reading of it, directly. I mean, you're speaking to the jury, you're asking for volunteers. There's only one set of people that could be directed
I don't know, when
to.
I first read it, I thought it was a generic reference to who would volunteer to do this, not how much would you take to go through this. That would be, to me, more of a direct golden rule type of argument.
Well, I didn't see that any contest to that being a golden rule argument, but again,
Put yourself in the plaintiff's place, Mr. Juror. How much would you take? Isn't that a golden rule?
Yes, Your Honor, it is. Yeah, that sort of overt statement, I think, would be a more plain statement. Yes, my imagination may be limited sometimes. But the idea of page after page of a closing argument being completely centered on asking for a volunteer and going so far as asking whether or not the plaintiff's counsel would volunteer, to take that. And I'll end on this point because it's the most difficult prong, and obviously it's something that this court considered as well in the City of Orlando versus Panero case. Murphy's not meant to close the door on errors that arise as a result of closing argument, and I know that the golden rule argument is one that is rooted in some of the concepts of religion, and what it says is in Murphy is usually the fourth prong is met by arguments that appeal to race, ethnicity, or religion. And Your Honors, I would submit that in this instance that this one comes and meets that standard. Thank you, sir.
Give me just a second here.
Sure thing, Your Honor.
Clock. Okay. Your opposing counsel was down to 50 seconds, so I'm going to give him an extra minute. So if you need an extra minute, you can have that as well.
I appreciate that, Your Honor, and I'm...
Why don't we start where he ended and tell me, number one, do you think the argument was proper? And number two, was it preserved?
I would like to answer with the second part first, that it was absolutely not preserved. I don't think there's really any debate about that. In fact, it's conceded in their brief that it is a fundamental error issue that they're going up on. So it was not preserved. The only question, and I don't believe it's much of a question, Your Honor, is whether or not it is nonetheless so fundamental.
Let's back up to question
Sure.
number one.
I'll be happy to. And the answer is it is not the best line of questioning, but it is, as Judge Lambert pointed out, it's not a classic golden rule argument.
But would you concede at least that if it isn't over the line, 1 foot's over and 1 foot's on the other side?
It is absolutely the kind of call that the referee on the field would say stands not confirmed. Your Honor's exactly right. It approaches that line. And it's always a difficult issue for plaintiffs on how to get across the concept of, we would love to give plaintiff her health back. We would love to give plaintiff her life back, but we can't. The only thing we can do is give her money instead. And when you're trying to make that substitution of money for things that money can't buy, there's only so many ways you can try to discuss it. The way that you can't do it, of course, is to directly say, what would it take for you to do it? So he tried to go with this volunteer, a hypothetical volunteer construct. But of course, it wasn't objected to. And even if it was objected to, it could have been properly dealt with a curative instruction. It could have been properly stopped before. We heard him say it went on for pages. Well, I don't think that the word pages is appropriate here, but to that extent, that's why counsel must make an objection. If you stop it when you think that it's there, then it doesn't go on for pages. But instead, they allowed it. And why did they allow it? The Murphy case goes through and talks about a lot of reasons why counsel might very intelligently and knowingly allow for argument that they think might be questionable to continue. That doesn't matter. What matters is, did they object or not? And when they don't object, this court in the Pinheiro case very solidly interpreted the Murphy decision to be clear that the Supreme Court has all but closed the door on civil cases for fundamental error, and the exception would be where they are each of those things improper, harmful, and incurable, and those things have much different definitions in a Murphy test than they do under normal circumstances. But the last prong, so damaging to the fairness of the trial that the public's interest in the system of justice requires a new trial, has been made clear to it must go to something stark, race, religion, ethnicity, and the idea that, well, the golden rule has its origins in religion is not an attack on anybody's religion. It's not requesting something. There was nothing about this volunteer hypothetical that in any way, shape, or form invoked John 3:16 or any other provision of the Bible or anything else. It is not a religious statement by the trial counsel. It does not fit the Murphy test. There's no basis for this to be considered under those frameworks.
Let me ask you to shift gears
Sure.
with me for just a minute. and address an issue that bothers me a little bit, and that is the future medicals. I mean, that number, when I looked at the evidence, it sort of seems, other than maybe the $5,000, that number sort of seems to be a lot of whipped cream. It doesn't seem to be founded in anything other than I like going to the chiropractor and getting 2 massages a week, and I'm 90 years old, but my father lived to be 100, and so I'll have to do this for an awfully long time. I mean, what competent, substantial evidence upholds, other than maybe the first 5,000, upholds that number?
Sure. And part of the answer to that, well, part of the answer is that her family really did have quite the longevity gene working in it, that her father lived to 102. She was one of the most active nonagenarians you're ever going to meet.
What competent, substantial evidence, other than the fact that she says, I like going to the chiropractor twice a week, and I like getting a massage twice a week, and it cost me $290.
Well, part of that answer lies in...
Where is the reasonable medical necessity testimony?
Sure. And part of that answer lies in the nature of the actual question that was posed to the jury and accepted by opposing counsel at trial, which didn't limit it to strictly medical expenses, but included household expenses and allowed for other elements of future damages to be included.
There was no evidence. All the evidence about, have to make accommodations in the house and all that had been taken care of by the time of trial.
That I think part of the answer can be best found in appellant's briefing.
Part you agree with?
That every once in a while they drop something, and we circle that when they do. And that would be the footnote 4 on the bottom of page 12, where appellants go through the examples of the testimony and the potential for the maximum alleged expenses, and they concede that maximum that was aggregated and presented to the jury would be $156,000. And of course, the jury still awarded yet more than that.
But that was accepting the $290 a week till she's 102 or something.
Sure.
And I mean, that was basically giving her everything. But let's just focus on that $290 a week for the chiropractor and the massage. What's the medical necessity of that? What evidence was there of medical necessity, reasonably likely to be incurred?
Right. And of course, another thing that must be pointed out is this is a trial where the defense offered no witnesses and no testimony of its own. So we have only...
They didn't have to prove your damages.
I understand. I understand.
What proof of your future medical damages? And if the answer is none, just say...
The answer is none save for the testimony of the plaintiff herself. And that testimony was clearly believed by the jury and accepted by the judge.
There was no medical testimony that says she really needs 2 chiropractors a week for the rest of her life, and she needs 2 massages a week.
We concede that, Your Honor.
Okay.
What about the voir dire? Is it waived? Is this argument waived?
The answer to that question is yes, that as you pointed out, Your Honor, if you're a trial judge and you have a jury of voir dire issue that comes up on day 1, and on day 2, they accept the jury. They don't renew an objection. They don't move for a mistrial. They don't move to strike the panel. Absolutely. And this court's case law, Goatee versus Clevenger, includes this quote that mandates that the claimed error be called to the trial court's attention once more prior to the swearing of the jury, so that the court will be made aware that the objecting party is insisting on the objection, and so that the court will have a last clear chance to take corrective action if needed. And then the court concluded it was necessary for plaintiff to renew the objection prior to the time that the jury was sworn. That really couldn't be any clearer, and there's a good reason for that. As Your Honor pointed out, that there are times when you want this jury, and that happens. And if the judge isn't notified before the jury's impaneled, the judge has to assume that everyone has in fact decided, for better or for worse, this is the right jury and we're going to go forward with it.
Do you think the questions were improper about the alcohol being involved in the case?
And the answer on that one is that the questions were proper, and in fact, while the initial brief tries to couch the really rather the reply brief couches the questions asked by defense counsel as trying to cure the issue that was raised by plaintiff's counsel. I think that it was incumbent on both counsel to find out whether these jurors were going to be the kind of jurors that might have an impassioned opinion about the potential effect of alcohol, because when you get to that punitive damage stage, and these same jurors would, it would be almost, in my mind, malpractice not to have made some level of inquiry regarding this. And the case law, the St. Paul Mercury versus either Cochet or Coucher case, makes it clear bifurcating this manner will always result in a jury being questioned about and hearing evidence of alleged willful and wanton conduct in the same phase of the trial in which the jury is required to assess compensatory damages. We cannot, and this is the Fifth DCA saying this, we cannot conclude that a procedure prescribed by the Supreme Court results in an excessive and unfair compensatory damages verdict. That controls. That is the case. The voir dire objection was not preserved, and even if it were preserved, the questioning was proper, and both parties engaged in it and needed to engage in it, because to not do so would allow for the potential of jurors who were very adverse to their case for emotional reasons, the types of reasons that jurors are not supposed to sit and make judgment, would have allowed those same jurors to sit. So the answer to those questions, Your Honor, is that no, the voir dire was not preserved and would not have been error even if it were. The closing argument was not preserved and would not have been error even if it was. And lastly, I think this court has made clear through its questions that the contract required, this court's case law makes it clear that performance must be an essential requirement for acceptance of the offer in a situation like this, and there were plain solutions for.
Let me ask, does our record indicate when the attorney, the niece or the granddaughter, Ms. Shaw, returned the checks?
I don't believe the record's clear on when the checks were returned. We only know that they were not received in the mode, place, and manner that the offer required. And the offer was very explicit about that, and the mirror image rule requires mode, place, and manner to be complied with.
She picked them up from the other office about 4 or 5 days after the 14th of December.
That sounds
I just
correct.
didn't see where, it seems to me that, okay, you missed the deadline, here's your checks back, game on, and I don't remember seeing that she kind of, held that as quasi-security to see how this went for a while? Or what?
It's clear that they weren't cashed, and it's clear that they were not accepted in the mode, manner, and place that they were delivered.
There wasn't anything in the record that I saw that said, okay, I'm sending your check back, here's, a letter back to the attorney, I can't remember who it is, saying, you missed your date and time, here's your checks back. We'll see how it turns out at trial.
The checks were not shredded and sent back with black roses. That is correct. That we don't know.
That's not significant in the analysis here.
I don't believe so, Your Honor. That
Been raised, I don't think.
Sure. The Trout case makes clear the mirror acceptance must have occurred. The mirror acceptance did not occur, and that they could have decided to have sent these checks. I don't know, before the last day before the acceptance, and they could have read the letter and did exactly what the letter requested and sent it to the address that was clearly stated in the letter. They could have resolved this many times before this letter was even sent. But if you're going to wait till the last moment and you're going to rush urgent by FedEx, if it's on a mirror image with a demand letter of no questionable notes on what to do, you ought to do it. And they didn't. There was no offer acceptance contract, and the judge below correctly entered his ruling accordingly. So for each of these reasons, appellee respectfully requests this court to affirm the judgment below. Thank you, Your Honors.
I'll give you an extra minute.
Thank you, Your Honors. Just one point. The court has hit on the fact that there's no competent substantial evidence within a reasonable medical certainty for the future medical benefit award, and we ask that be reversed and remanded. And
Or either a remitted down to the 5,000 or a new trial on that issue?
yeah, correct.
I know you want more, but I mean, as to that
We
specific-
would ask for, I mean, I think the court can or direct the remitted proceedings in conformance with the evidence. So we've stipulated to the 5,653 as part of it. And it's my duty, as this footnote that was referred to, it's my duty to say that the verdict form did allow for other types of expenses, and there was some testimony of $2,000 to $3,000 for wheelchairs, walkers, or chairlifts. And that's why I said it.
That was that wasn't future, that was past.
That's correct, but that's why that footnote is there, because that was something that was presented as evidence before the trial court. Thank you, Your Honors.
Thank you, counsel. Well-argued case.